Union Road Transport and Highways Minister Nitin Gadkari has moved the Bombay High Court over artificial intelligence-generated deepfakes and social media posts linking him and his family to the government's E20 ethanol blending program. The minister is seeking 11 crore rupees in damages, saying the content is false, defamatory and has damaged his reputation. The case centers around a series of viral videos, memes, AI-generated images and social media posts that allegedly claimed Nitin Gadkari was the driving force behind India's E20 ethanol blending program and that he and his family financially benefited from it. Gadkari says those claims are completely false. In an 86-page civil suit filed before the Bombay High Court, the union minister argues that he has no role in formulating, administering or implementing the ethanol blending program. According to the petition, the program is entirely handled by the Ministry of Petroleum and Natural Gas, while Gadkari heads the Ministry of Road Transport and Highways. The suit also points out that India's ethanol blending program began in 2003 and has gradually expanded to the current target of 20% ethanol blending for the 2025 to 26 supply year. But Gadkari's petition isn't just about correcting the record. It is also about how his identity was allegedly used online. The minister says several posts used AI-generated deepfakes, face swap videos, manipulated images and fabricated quotes to make it appear as though he had promoted the policy for personal gain. He argues that these posts crossed the line from political criticism into defamation and violated his personality rights by using his face, voice and identity without permission. The suit names several major technology companies as defendants, including Meta, X, Google and YouTube. It also names the Ministry of Electronics and Information Technology, the Department of Telecommunications, and unidentified social media users referred to as John Doe defendants. Gadkari has asked the court to direct these platforms to remove 26 links containing the allegedly defamatory content. Along with the takedown request, Gadkari is seeking 11 crore rupees in damages. Importantly, Gadkari says he is not trying to stop criticism of the government's ethanol policy. According to the petition, citizens are free to debate or oppose the E20 program. However, he argues that creating fake videos, fabricated statements and AI-generated content falsely linking him to corruption is not legitimate criticism but misinformation that damages his reputation. The case comes at a time when AI-generated deepfakes are becoming increasingly common. Advances in artificial intelligence now make it possible to create highly realistic fake videos and cloned voices within minutes. Governments around the world are grappling with how to regulate this technology while protecting free speech. Courts, too, are increasingly being asked to decide where political satire and criticism end, and where digital impersonation and defamation begin. This case is about more than Nitin Gadkari or the E20 program. As artificial intelligence makes it easier to create convincing fake videos and fabricated content, public figures and increasingly ordinary citizens are turning to the courts to protect their identities. The Bombay High Court's ruling could become an important precedent in defining how Indian law responds to AI-generated misinformation in the years ahead.